Okay, all right. Hey everyone, I'm Anubhav Garg. I'm management trainee at LawSikho, and I welcome you all in our today's session, how to get a notice issued by Supreme Court. And as a subject matter expert, we have Sanchita Ain ma'am with us. Sanchita ma'am is a advocate on record, and she has been practicing in Supreme Court for more than 6.5 years. And she has worked with some of the most remarkable people in this field, like Salman Khurshid sir. Passing on to Sanjita ma'am, before addressing the elephant in the room, why don't you tell us a bit about your journey as a lawyer?
Wow, I didn't know this would be a question, and this is a surprise. So I think my journey would come in course of the discussion because I was planning to put some elements into it. So in case you still have further questions on it, we'll come back to it. So let me first start with the session straight away, and I have really planned it in a way that my journey gets reflected while I discuss.
All
Right?
right.
So let's first start with where the idea of doing this came from. So I've been recently engaged as a script consultant, and it's very exciting to be, on board for writing a script for a series. So now this team of writers keep asking me how, like how do I go about it and how the different kind of procedures, can this happen? Can that happen? And I'm like, yes, of course, this can't happen, that can't happen, stuff. But they also have questions. How do you prepare your arguments? Right. So then I was like, how? Well, one person, I thought about it and I thought one person becomes a devil's advocate. We don't do it consciously, we just discuss. So give me a case and I can show you by discussing how we develop the arguments. But to kind of take them through and demonstrate how do we do it was kind
There
of
is no thumb rule.
initially not possible for me. So after a while, suddenly something happened and I managed to dismantle the entire process. And it took them through the entire thought process that is behind the arguments and how we develop it.
All right.
So as they call it, cut by cut, I took them through it and they found it very useful. Another instance was when some. Are you saying something, Anubhav? Because I
No,
can't
no,
hear you.
no, no.
Okay. So another instance was when somebody asked me, how do you research? So it so happened that I got to know that the person I used to work with before, not Mr. Kushit, before that I used to work with an AOR. So he used to miss my research skills after I left the office. So his junior asked me, how do you research? So I was like, you just put in keywords, right? How else do you research? But he didn't look that satisfied. And I also thought maybe I could have added more. What do I add? Right. The third instance was when a colleague asked me, how do you draft written submissions? Again, I said I can forward you the draft, but how again? So when all of these were happening, it also made me sit back and think, actually, how does it happen? If you have to uh, also explain and demonstrate the process of creation of something, how do you do it? Because in other fields, people do that, right? So that's what made me think of dismantling the entire process. And I, in fact, led a session with my interns. Some of them are here as well. I took them through how you would go through an impugned order that was more than 100 pages long. And one of them, in fact, discussed it with her classmate, and he came to me particularly to get trained in that. So that's when I realized it's useful for people, and this should be taught. So that was my personal reason for having it. But of course, you guys were also receiving requests. Anyway, so let's begin with challenges in getting notice issued, right? So now in a miscellaneous day, Mondays and Fridays, you have like 50, 60 matters listed before each court, right? And by 12:41 p.m., all of those matters get done. Which means what? Which means the judges already know the case and have made up their mind, right? So now sometimes you get a few seconds, sometimes you may get maximum a minute to address the court. And in fact, sometimes you first get an opportunity to address it, the judge will interrupt and say, no, 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 not happening. And you don't get to sometimes complete your argument, right? So that's the challenge, particularly with SLPs, where it's on the discretion of the court, it becomes particularly challenging. If you have if you have an appeal being heard as a matter of right, say statutory appeal or an appeal under certification, then this problem doesn't arise. But in SLP, of course, it's the discretion, as Article 136 would say. In writ petitions, also, just to make a prima facie case that a right has been violated, or sometimes you can also foresee that these issues may come up. And you have prepared so much at length on how to address when the judge asks you a certain question, but maybe he's not willing to listen to, right? So these are the challenges that one faces when one goes for a hearing. Of course, with senior counsels, you tend to get more time, but then they are more generous judges. They may be a little patient. They may be a little polite in throwing the file away, the way they throw or they say sorry to them. But that's the only difference, because ultimately you don't get much time. So how then do you face this challenge? Let's talk about the factors that would determine the issues, right? So if the judges have already made up their mind, then it's very important that what they have made up their mind based on your petition. So it's very important to draft the petition in a certain manner, particularly in these kind of instances where getting notice issued is tricky, as everyone would know. So we'll come to how the petition can be, drafted, keeping this in mind. But before that, after this process, when you're preparing for the arguments, when the case is listed before the court, then what do? Then what you do is you prepare your best argument. So you decide which is your best argument. Your best argument could be your foolproof argument, the argument that's the best that can not be countered in any manner. That's your best argument. But suppose it's a case where there's a gray area, what counterpoints would arise. Therefore, you still go for the best one out of the possible arguments. And then you have 1, 2, 3, 4, right? So it can be in a linear manner. It can also be, if this does not work, I'll switch to this. So like if I have to get notice issued on a matter where 302, 201 both are involved and the judge is not convinced on the 302 part, I say, oh, there's nothing said on 201. So then the judge will be, okay, fine. Just on that point, he'll issue notice on the entire matter. So that's another way of intervening in the situation and making it work for you, because all you're seeing at that time is how to get notice issued. Later on, when the matter is decided on merits, you may not want to emphasize on the same point. But for notice, some other point may be of more relevance, right? Suppose you have not been heard or you were not given opportunity. This in itself will be a very good point for getting notice issued. So unlike regular hearings, you're not getting kind of time to open and stuff. So when you are formulating your argument, then you also formulate it in a manner that is short, and you can also say it in a way that does not confuse the judges, right? So thinking it and imagining saying it before the judge, all of these help actually, right? Again, there could be certain judges before whom certain points work better than judges. So getting that is equally important. I'll give you an example. We were before just a C3 once, and I knew that he had delivered the first talk in memorial lecture, right? So what we emphasized on then was dignity, Dawkinian's concept of dignity. So when I drafted the written submissions, I brought in Dawkinian's concept, and it looked very academic at that time. I brought in Dawkins, I brought in other jurists, and explained what their concept of dignity was. And the briefing counsel still did think that was the reason why we got the relief we got. Having said that, the same Dawkinian principle of dignity and other jurists have been elucidated in all the leading cases thereafter. So just doing that exercise of understanding what particularly works before which judge is extremely beneficial. So it may also involve sitting in that court and observing the proceedings, not just on Mondays and Fridays, but on other days as to what works. If the same argument was made before another judge, would that work? This didn't work here. Would something else would have worked? These kind of exercises, if you even do a brainstorming exercises as students when you go to courts, if you're observant, if you just go to observe the judicial mind, I think it's a great exercise. I was made to do that by a person with whom I interned, and he just asked me to sit there till 4, whichever court you want to, and observe how judicial mind. That was the only thing he said. But when I would come back, he would ask me, "So what did you observe?" And I would say, "Oh, this happened." So then we would discuss, okay, if the same argument would have been made before another bench, or the same matter was before another bench, what would have happened? Before him, what he should have said. So all these exercises do help eventually. So I think as students, one should very much inculcate this, because later on you may not have so much time to sit in every court and do this practice, right? Then again, before Justice Local, once what worked was, we said, so we had our foolproof arguments and stuff, and suddenly we realized, so there can be unprecedented circumstances when your best argument, suddenly the judge comes up with something and you realize, oh, how did this happen? Like, I'm not prepared to answer this now. So you say whatever you at that point can make out of it. But what worked at that time was that I was not heard. So I was not heard was our last argument, because I was given opportunity, but I was given sufficient opportunity, yet I did not appear and I was not heard. So we thought, since sufficient opportunity was given, it's our weakest point. But that worked with it. So you can't really discard away any of your argument thinking this won't work, so let me not make it. At notice stage, any even 2 words may work. Suddenly you say, oh, was not heard, and they'll be like, what, not heard? And then you can further explain it, right? So that's what it is about. And again, there can be cases. There was one case where it related to breach of contract, and we were in clear breach. We didn't make the payment. We didn't make the payment even on extension. There was a trial court order, there was a high court order against us. We came before Supreme Court. So obviously the judge was about to throw the file. He said, what's there? There's nothing, right? We also knew there's nothing. We just argued, made an argument on sympathetic grounds, made it in a way that it worked. So how to approach it is very important. So when I say you don't get time to open, you still are opening, you still are uttering a word to open. So how you start, how you can hold the attention of the judge is important, very important, especially at the stage when the judge is not willing to hear, he has so many matters to do, right? Of course, there's human factor. As I said, that if it would have gone to a different bench, something else could have happened. Sometimes it so happens that notice is issued by one bench. Later on, it gets listed before another bench, and they say you don't have a case. They don't even hear you properly, and they say you don't have a case. So you get to know that if it would have been heard in the first place by this bench, notice would have never been issued. So that's how you realize how things vary, right? See, this human factor always would be there. So even if you are going for an interview, even if you are applying for an internship, this human factor stays. How I hire somebody may not be completely dependent on that person. It can vary, because I may give priority to something, you may give priority to something else. Yet, knowing how the interviewer's mind works generally helps. And in this case, you are also getting an opportunity to know how that judge's minds work, right? So this always helps to understand, and therefore this human factor should not be something that should be used to say that, that's why petitions get dismissed, we have nothing to do in it. You still have, just like you got to do with a job interview or an internship, right? So you necessarily, but in all these cases, whether it's this bench, whether it's that bench, there's a threshold. Now there's a threshold. If you meet that threshold, notice will definitely get issued. The problem is when you're not sure if your argument can meet that threshold, or if your case can meet that threshold, right? So what is it that you can do to meet that threshold? One thing that you can definitely do is to find a case, and really to find a case that had not been referred to before the High Court and therefore was not considered by the High Court. If you can find such case that relates to your case, that is in your favor, then of course notice will get issued and you also know that you will succeed eventually. So, all the hard work that needs to be done actually needs to be done at this stage. All the research, how you draft the petition, everything has to be done at the stage. Whatever you do now stays there, right? So, uh, here I would like to tell you. So some people say that it's luck, right? So, but you are not paid by clients to say this, that it's luck. You are paid to find a case that relates to it, or to find a way out. Find another way out, do whatever. Yeah, because that's what your job is, right? For luck, etc. Of course, eventually doesn't work. Of course, luck is involved. But just to say that, to give you an example, since you asked me about my journey, so all my internships, I believe I got through luck. So I'll tell you one instance. I got into Ministry of External Affairs, Legal and Treaties Division. It's in the ISI building. I got internship under the Joint Secretary. How did I get it? So I studied legal, right? So I used to take the morning passenger train. I used to leave at 6:35, and I would get up at 5:30, stand in the queue at 6 o'clock. There's just half queue for women, right? So I had to stand longer, board the train, come to ISIL, and I would come there and read. Or I would even go to ILI sometimes. So it so happened that day I was reading in ISIL library on war crime, with all the books spread out. If I would show you, even now books are spread out. They always work like that. So these bunch of people walk in. I don't know who they are. And they look at the book, they smile at me. I was like, whatever. So, and then I realized they're looking for something on war crime. They asked me if I can see this book. I said, yes. So then I asked them, what are they looking for? So they told me. I took a page out and I said, here it is. So they were very impressed. I didn't know who they were. They were the law officers of Legal and Treaties Division. So that's how I got into it. That was luck. But me deciding to get up at 5:30, go to the station, take a passenger train, and again come back in the evening after reading the whole day, that was my choice. That was my decision. That was not luck. So that's the point I want to make here. Right.
Great anecdote.
So how you approach the case, how you research, and how you draft a petition, all of this becomes very important at this stage.
Ma'am, so just to make learnings a bit more structured and easy to consume, can we summarize this answer? So first was making your argument short and precise, which induces clarity in the mind of judge. This was point number one. Second was try to bring into the notice of judge the points that has not been discussed in the lower courts, right? And what were other points? What am I missing here?
Right. So I think by and large, this is what it was. Yeah. So let me proceed, and then it will again come back. When I discuss how petition is drafted, it will come back. So in order to cross the stage, you really need to swallow any disappointment you may have had in the past and put the best foot forward each time you get it. So if drafting the petition is so important, now let's come to drafting, right? So if that is so important, let's see how it's to be done and what is to be kept in mind. So the first stage would be reading the impugned order. I'll just share a slide with you. I cannot see. Can you please do that?
All right, ma'am. Yeah. Now you have the permission to share the screen.
No, I do, but I cannot see the file I wanted to share. Maybe I can share from this.
Give me a minute. It's loading. Yeah. Which slide? Slide number, ma'am?
So just start with impugned orders, right?
Impugned orders. Got it.
So it must be fourth.
Yeah. It's loading.
Right. So suppose you have a very long order, say it's like 100 plus pages, and if you have a subjective opinion there that it's going to take a very long time to read it, and it's going to be a very tiring process, how will I read it? Then you'll be tired even before you start. So the first step that we tend to ignore, and we think that we suddenly start reading everything, but it's always good to pause and rewire how our brain works. Let that thought settle down and then start reading, right? And then you bring your two skills into play, right? So whenever you're ready, you can bring this slide.
Yeah.
Now so the first one is skimming and the second one is scanning. So you must have heard about these, but let me just explain in my own way. So suppose you have a buffet, right? So what would you do? You would first look around what all are available to eat, right? I'm a foodie, so I'll give you that example. So when you do that exercise, what are you doing? Actually seeing all that's available so that you know what you would want to eat, right? So that's scanning. That's basically marking the territory, just like a dog would do, go around and then make it its own, right? So this is the exercise when you are going through the entire order. If it's a shorter order, of course, it's not a problem. You can read the entire order. But if it's a longer order, it's always beneficial to first flip through the pages and see, right? And when you're constantly going through it, you're marking the facts because that will be the first that will come. Then the evidence in case of criminal cases, then you have submissions, you have findings, right? So this is your first step. This always helps when you use it as your first step. Can you bring this to the next slide? So my father was in paramilitary, so I tend to bring out rules into everything. So once we have skimmed, let's come to scanning. So when you are scanning, go back. Yeah. So it always helps to start from the findings part because findings mostly have the facts given briefly. They'll discuss the submissions and then they'll come to the ruling. So when you're scanning anything for that matter, you're looking for something. You're scanning in order to find something. Like in a buffet, then you go back and you are looking for something in particular that you want to have. Particularly when you have less time and you know you can't have it all, then you all the more scan in a manner so that you can reach what you want, where you want to go, right? So when you're scanning find the findings, you are reading in a manner that you're looking for how to show that the High Court has failed to deliver substantive justice, right? So these are the main grounds on which an SLP is challenged. So you see 136, Article 136 does not talk of any grounds. It says it's on the discretion of the court. But through reading of case laws, these are the broad heads of grounds, you can say, that you can keep in mind. So the first one is High Court failed to deliver substantive justice. You need to show how. So when you're reading it, keeping this in mind helps. Then how the order of the High Court perpetuated grave injustice to the parties. The third one would be how the offense, act, or omission was of such a nature as would shock the conscience of any court. So this may or may not be there in your case. You may find all or one or two of these or more than that, right? Then how the judgment suffers from disregard to the forms of legal process, right? The last one is violation of principles of natural justice. So keeping these in mind definitely helps. Can we go to the next slide?
Yeah, sure. How to research?
So after you have scanned it, you you in fact, of course, you're reading it as well. So there's no substitute for reading. So once you've scanned it, you find something important, you go back to say facts to find out whether this thing had really happened, or what were the circumstances in which it happened. So you keep referring back and forth, right? So if it's a physical copy, now we are getting used to the soft copy. So I'm saying you go back and forth, but you go back and forth, right? And you, in a way, you manage to read the entire file. When you do this exercise, you need to remember which page, where exactly, where you have found which point. So that's why doing scanning and skimming before reading always helps. While you are doing this, you are also going through the documents that were filed before the High Court that's going to support your case. So generally, you can file all the documents that were filed before the High Court because mostly they are relevant. In exceptional cases, you may find something is really not relevant and you may decide not to file. But sometimes you may also think of a document that's not on record that may help. So you call your client to ask if that's available. They'll say, okay, we'll find, etc. So now if it's very crucial document to get notice issued, then you what you do is you file your SLP under defect and you wait for that document. If there's a limitation period that you have to take care of, then you file an IA for permission to file additional documents before the matter gets listed. So if it's that crucial for notice to get issued, you don't file simply the SLP without the IA. Howsoever, it may be delayed, it may be 300 days delay, 400 days delay. You don't do that. You then file it in defect, and then later on you file it so that it goes to court together. Or if the client says, no, it will come within a day and you're very sure that it can be filed the next day or something after you have filed, then of course, before the matter is taken up, you can file. In the meantime, you can file so that both are on record, right? So it's very important to keep that in mind on when to file. If it's a document that may not be that much necessary, but may come into question later on, it should be filed, then of course you can file. There's always an option. So now we come to how to research, right? So once we have gone through the impugned order, now we have also seen the documents, it's all in place. Now we start our research. So the first step would be to restate the issues in the form of legal propositions. The form in which you generally expect to find them in a judgment, right? So legal propositions would be statements in the form of statements. Issues would be a kind of a broader kind of it can be different. It can be issue can be whether it is violative of Article 14. That's an issue. The form in which you expect to find it could be a little different. So you need to actually think what the legal proposition would be, in what form you are expecting it to find in the judgment, and restate the issue in that form. So it can be multiple legal propositions under one issue. The second would be preparing to find it. So that's one kind of psychological stage that I always like to point out when I'm talking to interns or when I'm talking to young professionals. So you need to prepare yourself to find it. Sometimes what happens when you ask an intern to find something on a legal proposition, they say, oh, I get to know that they won't be able to find it. Why? Because they're like, man, this one would be difficult to find. I can find on this, but this one, there won't be a case, or it would be difficult, right? So in that case, you're blocking your effort making capacity there. So one way is to rewire your brain. It's always possible to do it over a period of time, so that as a matter of habit, whenever you look at a legal proposition, you're ready to plunge into it. You're sure that there would be a case somewhere that would be relevant for you. Some judge somewhere would have said it exactly in the same words, right? So now the third step would be choosing the keywords from these propositions that you have framed, right? So when you choose these keywords, sometimes it's easy to find. There will be limited number of hits, or it's by relevance. You'll find it by relevance. So you can find that quite easily. You may go through the digest note and you may see that, yeah, it's relevant, I found the case. But sometimes there would be many hits, and then you're struggling to find the exact relevant case that you want. So filtering them subject-wise sometimes helps. So once you look at the initial cases that you have found, you will realize that something is going wrong. What is going wrong? It's getting too many hits because maybe you have to find something from contract law, but it's also showing something from, say, corporate law and stuff. So then you filter it. Then sometimes even adding a word to make it unique also helps, because when it will be unique, then you'll get limited. So then you try that also. Maybe search within search you do. Then using OR. So this I learned during an internship. So what happened was I was asked to research. So internship again, we didn't have access to SCC or Manupatra in our college at that time. So our college was used to train us for judiciary, and we would focus on basics. I mean, nobody can match us on that stuff like that. But we didn't have, at that time, we didn't have access to SCC Manupatra. Right now it's there. We also didn't have Wi-Fi. I didn't have computer. I think one of our friends had it, and everyone used to use it. So when that happened, the only way to access, I didn't have a subscription to. So I would get to access SCC and Manupatra only during internships. That to I think there was one internship where I didn't even get to access because all these systems were engaged and stuff. So the only time when I got, so after that when I got to access it, he asked me to find a case, the associate, and I found everything else, but I didn't find the case that he had already found. So he said, there's one case that you haven't found. So I said, okay, let me go back. Give me some time. So I used to fiddle with Manupatra and SCC like I was a child fiddling with a toy. I would reach at 9:30 a.m. and then I would sit there till 8:30 trying to understand what it is, right? So I was putting in all sorts of keywords and I kept trying, that's how I learned trial and error methods in research. So there's no substitute to that, to practicing, right? So finally I gave up. After say 2 days or maybe more than 12 hours, I gave up. So then he told me the name of the case. I found it and I realized I had been using the keyword internet, whereas the case mentioned website and it didn't mention internet anywhere. While the other cases mentioned internet, right? And there was no way I could see that coming. So after that, I learned to use, synonyms with OR. So internet or website is what I would now put. So that's one of the things I wanted to share. You can go to the next slide now. So let me also tell you that even when let me take you through common mistakes and then I'll go to what do you do when you hit a dead end during research. So common mistakes would be that, or maybe let's first take you through what do you do when you hit a dead end in research. So sometimes what happens when you're reading the impugned order, you realize that, the case is completely against you. The case that is being relied upon by the judge in the impugned order is completely against you and there's no way you can succeed. Maybe client also knows it. What do you do? So it happened with me once when I really hit a dead end. Like there are times when you feel you won't find anything and then you ultimately find, all those are fine. But when I really hit a dead end, that was a case where it related to industrial tribunal. Okay? And industrial tribunal gave an award that was in our favor. But the other side's argument was that it was not done by an appropriate authority. So the whole award goes in that case. So what do you do? Because there's a case that says that the concerned organization was not governed by the appropriate authority, by the government that had initiated it, right? So if say the state government is not the appropriate authority for that particular organization, and say if there's a case that says that this organization is not governed by this authority, for this organization, the appropriate authority under the Industrial Tribunal Act would be center. So what do you do then? You think there's no way out, right? So then I realized what works in those situations would be, I don't know if you guys prefer, I can't use, okay, so let's forget that. I thought I would do something on whiteboard. Can you bring the whiteboard for me? Let me try.
Yeah,
Yeah, I don't know if you guys like pictorial representations. It's sometimes easier to remember stuff. So let's
sure.
see. Would I be able to do it if you give me access?
Yeah, man. You have the access.
I have the access, but I can't see the whiteboard.
Ma'am, you have to go to the advanced options. When you will tap on the screen share button.
So advanced, I can't find whiteboard. It's generally in the basic, but I can't see it even in the basic. So it's okay, I guess. It's okay. Let me just say it. Yeah. So suppose you're building a case, right? And you hit a dead end. So what I'm asking you to do is you, again, imagine there's no dead end, because the moment your mind knows there's a dead end, then it refuses to think ahead. It refuses to think differently. So once you've imagined there's no dead end, then you start drawing out the different pathways. So in this case, what I did was I started building up arguments based on general principles. So in this case, the appropriate authority was Delhi, right? So, or the authority that had initiated the process was Delhi. So I started with thinking, I mean, is Delhi different? Is the case of Delhi different? Because it has a different status. So from there, I started building upon a case, and I started finding cases relating to this general broad principle. And I came across a DB judgment that said in as many words that in case of Delhi, this is what will happen. That was in my favor. That was not considered in the single judge bench that was being relied upon by the other side, which means it was per incuriam, right? So once I did the entire exercise, then it looked simple. Then when we went to brief the senior, it looked simple to him. It was like a open and shut case. That's what happened. The bench also was in our favor. So that's the thing. So you can make it look very simple and easy just by doing a thorough research, right? So that's what you do when you hit a dead end. So now let's see how do you draft a petition then? So you begin with, so I begin with list of dates. Because once you have the list of dates, you have a general idea about the matter. You have it for reference all the time. And sometimes you'll realize that there's some gap in the facts. So you call the client, you check with them, you clarify, and they say, this had also happened. So do you have a document to show that? Yes, I have. Right? So it helps to fill the gaps as well. That can be in your favor. That can be very crucial. It also gives you a perspective that may be missing, right? So it helps to draft a list of dates in a chronological manner. Then, in fact, how it also helps is once I did this whole exercise, there were facts missing. I called up the client and I asked him to send me certain documents. Right? He didn't know what I'll do with those documents. Finally, when he drafted the petition using those documents, he told me, Sanchita, I finally realized what my business partner had done to me. So he didn't know, he just knew the broad things that was done, but how it was done was something that I got to understand while preparing the list of things. So it can be that crucial, right? Now, then I draft the grounds. So list of dates, then grounds, and then I go to synopsis. After that, I draft the rest of the petition. So synopsis is the most important part, particularly in cases where getting a notice issued is very, very tricky, right? So sometimes, why is it so? Because sometimes the judges only have time to go through the synopsis. So you understand, even if someone else is going through it, even if they have help, but even then they will also just cursorily, just scan through the pages. So you have to understand the process in which you would do it. You have to imagine yourself doing it when you have so many files with you. So in that case, you draft it in a manner, you make it brief, you make it precise, you make it crisp. right? So again, in synopsis, as a matter of fact, you cannot highlight or underline anything in the petition. In Supreme Court, it will come as a defect. So then if you cannot do all of that, then how do you work on the synopsis so that it catches the eye of the judge? So what you do is you divide into paragraphs and you begin every point and you have one paragraph for each point. So you don't mix the points with each other. And in the first line itself, you quite crisply mention what you want to say. Instead of using like in other kinds of writings, you have an opening sentence, then you slowly elaborate and stuff. Instead of doing that, the first point should hit the bullseye, and after that you can elaborate in that paragraph, so that if the judge wants to understand, then he can further read and understand. Because generally when you're scanning through any document, what you tend to do is you tend to read the first line carefully and then you skim through, right? You again read the first line, you skim through. So that's how you do. You may not be very conscious about it, but this is how you do it. So let's focus on making the first line very, very something that you would want the judge to really read, right? Then you first, of course, start with the impugned order against which you have come, and then you talk about the relevant facts very briefly, only the relevant facts. Then you have a central idea in mind. By the time, why I say you draft the grounds first is because then you understand what is going to be a central idea around which your petition, around which your case will revolve. So suppose, and it can be two central ideas as well. Two ideas can be part of the same central idea. So it can be that a question of law was not considered by the High Court properly, or it did not consider a case that it should have considered, right? So then what you do is everything in your petition should lead to that conclusion, should relate to it. If it does not, then you're missing something. You're either writing something that's unnecessary or you're missing the point somewhere. Then after you have kind of made those submissions in different paragraphs, then you just mention the grounds in a crisp manner. So the synopsis doesn't have to be really long. Sometimes people tend to repeat the same things again and again. That's really not recommended, because then that the risk is that sometimes someone may not read the main point, or someone will miss one or 2 points here, right? So after that, you state all the grounds in a short, crisp manner, just one line, and then the relief that you're seeking. That's your synopsis. That's it, right? Now, remember, we can go to the common mistakes slide.
All right.
So guys, it's just that you need to keep using your creativity. Developing arguments or grounds requires a lot of creativity. So to acknowledge that, to appreciate that is important. Once you have developed this, so it's like developing a structure. Once you've done that, you can look at it, you can admire it, even your client can appreciate it, because it's part of closure for her or him as well. Sometimes clients would know that there's no chance of succeeding, but they still come to you because they in fact look around, they find somebody to do the case, they spend money, they repose trust on you so that you can, at least give them a closure, right? So one of the purposes of drafting a petition, of coming to High Court or to Supreme Court, is to get a closure for the client. So to fulfill that is part of our job, I feel. And therefore, the client should. So one of my experiences was when the client read the synopsis and she said, Sanchita, I don't know about law. I don't know anything. But I just know this much, that anybody who reads the synopsis would know what has happened. Right? So that's how it should be, that the client is also satisfied. I think client satisfaction is very much part of our job. So the common mistakes is the petitions are too long, repetitive, right? So sometimes people think that if they make a thick one, it will give an impression that there's a lot in it, but that's not how it works. Then you make it a piece of literature rather than a technical document. Or sometimes people use colloquial language rather than the language used in authoritative sources like statutes and judgments. So reading a lot of judgments does help to develop that language. Sometimes it can be too general or vague. That's why I say having a central idea helps so that you can keep relating it to the central idea all the time, right? Another aspect that you need to keep in mind, so I'd read it in a book on drafting when I was a student, show, not tell, right? And it confused me because I was so used to using certain words to emphasize that this clearly shows that this, right? So I was wondering if I shouldn't use those words, that's what it means. But I continue to use it. Now at this age, when I look back, and now I also realize that show not tell is a very well established principle for any creative writing. You'll find substance on it on internet, and I mean people have written so much. All the authors follow it and stuff. So show not tell would mean you connect your thoughts in a way, you connect your points in a way that to make it look obvious. You connect your facts, your arguments, everything in a manner. So one example would be, so say somebody has not done something and you say that person deliberately did not do it. On say first, this happened. On 16th, he did it. So he did not deliberately do it for 15 days. Instead of that, you can say on so-and-so date this happened, but he chose not to do it for 16 days. Like that. So, I mean, so you put it in a manner so that the only conclusion that it can lead to for any person who's reading it would be this. Because nobody wants to be dictated, right? So if you're dictating the person saying that this is my conclusion, you have to understand, this is the conclusion, this is what you need to understand. You say 1,000 times, he won't understand. You just show it to him how you it's say deliberate action or how it's breach or whatever. Then the person automatically reaches that conclusion, and that's what is more effective. That does not mean you do not use words to emphasize. You definitely use words that clearly shows and stuff, but that does not take away this anything from this principle that you have to should show and not tell, right? Again, there are times when you need to tell. So at that time, you of course need to tell, say the facts. You need to tell. But when you're connecting them, so you can use a language that works, that helps in showing. So you can use connecting words also, right? Thereafter and stuff. So after a long period, so like that. The next thing that I would want to, so I'm about to end it. After that, we'll take questions. Uh, so, so this is about negative capability. So Keats, the famous poet, he talked about negative capability. And he said, he gave example of Shakespeare. So when he talks about negative capability, he talks about various aspects of negative capability. So one aspect will be the ability of a playwright or an author to stay with the character, to stay with the doubts, to stay with whatever the character is going through, to stay with it without judging the character. Right. So this is what he calls negative capability. So another aspect of it has been beautifully described by Markowitz in relation to professional ethics for lawyers. And I'll quote him. Keats argued that the negatively capable poet is unusually able to efface himself. This is very important. I don't know how many of you agree that a lawyer should be able to self-efface. A negatively capable poet is unusually able to efface himself, maintaining no identity of his own, and to work continually as a medium, filling some other body, the sun, the moon, the sea, and rendering the extraordinarily mute body articulate. So this part is so beautiful, rendering this extraordinarily mute body articulate. So that's the job, making what the clients would want to say articulate, so that the client reads it and says, yes, this is what I wanted to say. So developing that kind of language is important. Reading judgments, reading articles relating to that may not be legal articles, that can be relating to social issues. Say you are working on a case relating to discrimination, right? You're challenging this issue. So reading articles on exclusion of different classes helps. So you get that kind of language. Doesn't mean you turn it into an NGO report or a letter that a layman would write. But still, I think you can then use, you know how to blend that language. Also, before you start drafting, it's a very important exercise that you mandatory read it. Even if you know the landmark cases and you know you don't need to research at that point, still go through it because it will refresh your memory on language. What kind of language to use? It will automatically start flowing, right? So that's why I say you are a medium, because it starts flowing through you in a manner that you find yourself, you find effacing yourself. So that's it, guys. Just we can take questions now.
All right. So let me just open the chat for attendees.
Sure, please. So I say bring it home because it's very important to kind of, you know what bring it home is. So to make somebody understand something is what bringing home would be, bring something home.
Yeah.
So yes, keep
So now
practicing.
you guys can type your questions in the chat box, or ma'am, can we take the questions live also?
Yes, of course,
All right.
please.
So you can also unmute yourself and ask your questions directly to Sanchita ma'am. So if anybody has any query, please either type it in the chat box or raise your hand in the Zoom and unmute yourself and directly ask. Please go ahead. No query. Okay. Sanchita, this is the proof of great subject matter experts that no one is left with a single doubt in their mind.
I'm humbled, but I hope somebody, I mean, I hope people got what I said, and it's not because I.
I don't think so. I understood everything, and I'm just in the second
Do
year
you
of my
have
law
any
school.
question, Anubhav?
Not so far, because I am clear with everything. Uh, uh, Nothing on YouTube chat as well. Okay, all right. So, do anyone has any other question? Other question? What? Okay. No. So I think we can call it a day. What do you think, ma'am?
Sure. I think we still, if somebody wants to make any comment, I think I'm very much okay with it. If somebody
How
has a
to
comment.
make argument if there are several errors in judge mention? Okay, so I think Sachin Salunki is asking a question: how to make arguments if there are several errors in the judgment mentioned?
Right. So if you're talking about the notice stage, how to make argument at the notice stage, because that's what we're concerned with at the moment. So if there are several errors, and by errors, I would assume that, legal kind of things that the court should have considered. It involves questions of law, right? Those kind of errors that the High Court should have considered something, High Court erred in not considering something, right? So if that happens, then of course you can bring all that up. So when you're drafting the petition, you bring all that up in the petition. But when you're arguing it, you may not get time to cover them all. Therefore, when I was talking about having that, first you need to come up with the best argument, you need to devise it in that manner so that you have it for best argument, then you have the next argument. If this doesn't work, then I go to this. That doesn't work, I go to that. That kind of strategy you need to have. If you have multiple, you have found multiple errors in the judgment, then you pick up the best one that will make you get the notice issue. You pick up that.
All right.
Yeah.
YouTube chat. How many grounds we can take in a single petition?
Well, I have seen ZA also. I've seen ZA N also, I don't know. But you can take as many. There's nothing wrong in it. But you can always, so sometimes people get very anxious by that, if I don't make it exhaustive, then what happens? So the last ground always is any other ground with the permission of the leave of the court. So you can take up any other ground at a later stage also. But when you're covering it, I guess ideally it gets covered when you have like 10 grounds or something. I don't think, but then if you feel there's a need, then you can have more. There's no limit as such.
All right. No other question. So if anyone has any other question, guys, please come ahead and ask. There is no such barricade. And
Devyani, do you
please
have a question?
remember that no question is stupid.
Devyani?
Yes, ma'am. Hello, ma'am. No, ma'am, I don't have a question right now. We already had this session before as well. So it just helped me to get a clearer understanding of the whole thing now.
Right.
Okay.
Yes, ma'am.
All right. How to start the arguments? Shehnaz Ali. People, now you can send your questions in the everyone column of the chat also. I have enabled that. I just disabled it for the session's sake, and now you can type it there as well. So yes, send it to me privately. Shehnaz Ali, how to start the arguments?
Right. So again, as I said, that if it's at the notice stage, if you're arguing post notice, then you'll have to mention that. But if it's at the notice stage, then there are two ways. If you know it's a lost case, then you really work on your craftsmanship. Then you really try to approach the judge in a manner that will touch that point that would make it work for you. Right? So then you start like that, but you obviously use the same arguments that you would have used for any other judge, but you put it in a manner that it's effective.
All right. Okay, so in the meantime, why don't we collect some feedback? So, guys, can you please rate this session on a scale of 1 to 5, with 1 being the lowest and 5 being the highest, so that we can get a sense of the feedback, how we did and how we performed, and whether we were able to deliver to your expectations or not. All right. Thank you, Sachin. Come on, I'm not closing
Thank you
the
so
session
much,
until I
Sachin, for
get
a
feedback.
5.
Quickly. You just have to type 1, 2, 3, 4, or 5, whatever, so that we can serve you guys better.
5.
5, Anil.
I got
Okay.
a second 5.
YouTube, on YouTube, 9 people are watching us, but no one is sending us feedback. Come on, please. It really motivates us to. Yeah. So many people are asking about the PPT. So we will be sharing the PPTs on LawSikho's WhatsApp group. I have sent a link in the Zoom chat. Let me send it again. So just sorry. I sent it to someone privately. Yeah. So this is the link of the WhatsApp group. Please join this group, and all the PPTs will be shared here. Okay. Thanks, Devyani. Thanks, Shehnaz. Thank you so much for your feedback. Vivek on YouTube, thank you so much. All right. So I think
How you have to tell the score also.
yeah. So they have given you a 5.
So you have to tell that.
Yeah. So Shehnaz 5, Divyani 5, Vivek Maskar also 5. Thank you so much for being so kind for this stellar feedback. Acha, if would anyone like to come live and share his learnings in a nutshell? Just a line or two. What new you learned from this session? Anyone? You can unmute yourself and come live. Nobody. So Sanchita ma'am, what do you say? Can we call it a day?
Sure. I had a great session. Thank you so much. I really liked being here as a speaker.
All right. Also, we are also very grateful to you, ma'am, that despite having your matters piled up in the court and despite having your hands full, yet you spared us the time to come and enlighten us. Thank you so much. It was a very interactive session. I personally learned a lot. So, humbly and I'm obliged. Thank you so much, ma'am. All right. So,
My
okay,
pleasure.
guys,
Thank you.
it's time for adieu. Break a leg. Take care.